Hello, and welcome to Wills for Healthcare Heroes, an initiative of Virginia's Wills for Heroes program. My name is Melissa Moser. I am an attorney in Virginia Beach and one of the co-chairs of Virginia's Wills for Heroes program. This presentation is for potential clients of the Wills for Healthcare Heroes initiative to inform these potential clients of the services that we are offering and the parameters of our program. Wills for Heroes is a nationwide nonprofit organization that was created following the devastating events of September 11th, 2001, when it was discovered that many of the first responders who perished in the line of duty did not have any estate planning in place. Wills for Heroes is a program where volunteer attorneys prepare basic estate planning documents for first responders for free in appreciation of their service to the community. First responders is defined as law enforcement, firefighters, and emergency medical technicians. But during this unprecedented time, we are expanding the definition to include healthcare workers on the front line of this pandemic. Offered in Virginia since 2003, the Wills for Heroes program is presented by the Virginia State Bar Young Lawyers Conference and the Virginia Bar Association Young Lawyers Division. It is sponsored by Virginia CLE and made possible with a generous grant from the Virginia Law Foundation. The Wills for Heroes program offers 3 basic estate planning documents consisting of a last will and testament, a springing durable general power of attorney, and an Advance Medical Directive, which includes a living will and a healthcare power of attorney. We will discuss later what each of these documents entails. To be eligible for this initiative, you must be an essential healthcare worker, which may include contract employees. You must be working on site, so not virtually, not working from home, but actually on site at a healthcare facility which is providing care to COVID-19 positive or presumptive positive patients. And you must be a resident of Virginia. To be eligible to have a will provided for you, the value of the assets you own, including the death benefit proceeds of any life insurance policies you own, may not exceed $11.58 million. I would presume that anyone whose assets exceed that will probably have hired an attorney already. But just in case, we want to make sure that you know that if your assets exceed that, this program would not be for you because you would require more sophisticated estate planning than what this program offers. Also, if you own a business, you're still eligible for this program. You can own it individually or you can own it you and your spouse. But if you own it with anyone else who is not your spouse, then you are also not able to have a will prepared through this program. Again, due to the need for more sophisticated estate planning. However, even if you are disqualified from having a will prepared, you can still have a power of attorney and Advance Medical Directive prepared through this program. If you have any questions about whether you are eligible for the program or any other questions regarding Wills for Healthcare Heroes, please contact virginiawillsforheroes@gmail.com. How do you participate? Well, eligible participants must watch this presentation, which explains the parameters of the program, the documents you will be receiving, and the choices you have. You must then complete and submit the Wills for Heroes form, which incorporates our engagement agreement defining the scope of our representation of you, and the questionnaire in which you make your estate planning selections. Participants will be assisted on a first come, first served basis. After submitting your Wills for Heroes form, you will be contacted by a volunteer attorney for the purpose of confirming, scheduling and confirming a meeting time. At this meeting, you and the volunteer attorney will then go over the documents prepared for you. We are offering this program virtually for the safety of you and the safety of our volunteers. And so this will all be done virtually. Therefore, you must have an email, a telephone, cell phone, um, and internet access. Additionally, because this is in effect a virtual clinic, you will be responsible for getting your documents properly executed. We will be giving you instructions on how to get them executed, but you will be the one who will need to get two witnesses and a notary together in order to get your documents executed. So your virtual meeting with the volunteer attorney will consist of the attorney going over with you the important provisions of your documents. You should make sure to ask the attorney any questions you have to make sure that you fully understand the documents that have been prepared for you. It'll also be important that you review these documents for errors, whether it's spelling errors or errors in addresses that are listed or selections that were made. The volunteer attorney will be able to revise these documents as needed during the meeting. The attorney will then email you a PDF document consisting of your estate planning documents, a termination of attorney-client relationship letter, and instructions for the execution of your documents. So there are some program limitations that you need to be aware of. This is not an ideal estate plan for everyone. The choices that you have uh, are fairly basic, and there's not a lot of flexibility offered with this program. Uh, you have choices with your estate planning documents, but the volunteer attorneys are not drafting different documents for each client. So if you have more sophisticated needs, or if you have other desires for your estate planning outside of what we're offering, that's when you would need to get your own, hire your own attorney to draft that for you. This program also does not offer estate tax or probate tax planning. And this program will not account for major changes of circumstances. Our representation of you will end upon the delivery of your documents to you. So if you're not eligible to receive a will under this program, or you desire a customized estate plan that is different from that which we are able to offer under this program, please feel free to contact an attorney through the Virginia State Bar Referral Service. Their number is 1-800-552-7977. So let's first discuss the legal document that controls upon your passing. This document is known as the last will and testament. This is a legal document in which you specify who receives your assets, who you wish to look after your minor children, who will be charged with the responsibility of administering your estate, and who will be charged with administering any trusts created under your will. Why even have a will? Well, first and foremost, it offers you control. You decide who's going to receive your assets. You name the person who is going to be administering your estate and trust. You choose whether that fiduciary should be compensated and whether to waive surety on the executor's bond, and you name the person you want to be the guardian for your minor children. Without a will, uh, these would be decided under Virginia law and or by the court. Additionally, having a will offers you a peace of mind, knowing that your wishes will be followed and that your family will be taken care of in the manner in which you've prescribed. So what happens if you die without a will? Well, the Code of Virginia has implemented default rules that apply if you die without a will. First, if you're unmarried and you don't have any children, your assets go to your parents. If neither of your parents are living, then the assets would go to your siblings. If you're not married, but you do have children, all of your assets go to your children. If you're married and do not have any children, then all of your assets go to your spouse. If you're married and you do have children, and all of those children are also the children of your spouse, then all of your assets go to your spouse. But if you're married with children and have at least one child that is not also the child of your spouse, then 1/3 of your estate goes to your spouse and 2/3 are divided equally among your children. It's important to note that until there is an official divorce decree, you are still considered married. What assets does a will control when we talk about your estate and probate? The assets that a will control are those assets which are titled in your name alone that do not pass by survivorship or beneficiary designation. These might be bank accounts, stocks, bonds, real estate, and tangible personal property. Assets may also include those assets owned by others where you or your estate are the named beneficiaries. This might be insurance and retirement accounts. Assets that are not controlled by your will or that are outside of probate include those assets titled jointly with survivorship with someone else, and these might also be bank accounts, real estate, etc., and those assets having completed beneficiary form designations, which name a third party as the beneficiary. These might include insurance, retirement plans, and IRAs. So here, next we're going to discuss the options that you have under this program. First, your choices are you select whether you're married or unmarried. If you're married, your choices are that your spouse receives all or a percentage of your assets outright, with the remainder going to your children or others that you select. Or you can choose all or a percentage of your assets are held in trust for the sole benefit of your spouse during your spouse's lifetime, remainder to your children or others you select. If you're single or divorced, widowed, otherwise unmarried, your choices are all to your children in equal shares and or all to named individuals in equal shares and or all to a charity. So if you select you want your estate to go outright to your spouse, this option provides that upon your death, all or a portion, depending on if you select you want a certain percentage to go to your spouse, with all or that portion will be left outright to your spouse. If your spouse predeceases you, your assets will go to your children. If any children would receive assets but is under the trust age threshold, your trustee will hold the child's assets in trust for the child's benefit until the child reaches the trust age, when the assets will be distributed outright to the child. We'll talk about that for a second. Trust age is an age that you're going to select, whether it's 21, 25, 30. It's the age that if these assets are, if you have a minor child who is to inherit, their assets will be held in trust for them and for their benefit while they are a minor. And then when they reach what we're calling the trust age, they'll get all of the assets, whatever's left, outright from the trust. But those assets that are held in trust can still be used for them um, while they're growing up. It's just that once they reach that trust age, it's not going to be held in trust for them any longer. So when you leave everything outright to your spouse, you have no control over the assets after distribution to your spouse. However, if you were to leave your assets in trust for your spouse, this format provides that upon your death, all or a portion of your assets will be held in trust for the sole benefit of your spouse during your spouse's lifetime. Upon your spouse's death, the assets will be distributed to your descendants. You select a trustee to manage this trust for the benefit of your spouse. The trustee controls the trust assets pursuant to your instructions in the will, such as for the health, education, maintenance, and support of your spouse. This arrangement is commonly used as an effective way to provide for both your spouse and for any children from a previous marriage. Another way to say it is that if you have a blended family, this is a common technique to make sure that your spouse is provided for, but that children, including children from a previous relationship, are provided for as well. This technique allows you to retain some control over assets that are made available for your spouse's benefit. So if you choose the option for your children to receive your assets, again, this is where you can select the age the trust will distribute your assets. Any child who would receive assets that is under the trust age, in that case, the trustee will hold the child's assets in trust for the child's benefit until the child reaches the trust age, at which time they are distributed outright to the child. It's important that in this program, you name the children that you want to take as children under your will. Of course, this will include natural and adopted children, but if you want stepchildren to also take as your descendants, as if they were your descendant, you must specifically name them because they're not considered children under the law unless they've been legally adopted. If you'd like to name some individuals to receive your assets, you can leave your assets to a specific person or a group of persons in equal shares. So to emphasize this point, you could say, I want to leave everything to my neighbor. Um, but if you have a group of people, you can't say, I want 30% to go to person A, 20% to person B, and 50% to person C. When there's a group of individuals that you want to leave your assets to, it will be divided in equal shares. You can select whether you want a beneficiary's heirs to take in their place if that beneficiary dies before you, or you can select that no, the heirs should not take in the place of that named beneficiary. Note that this selection will apply to all future named individuals as well. Charity. Leaving to a charity is another option in this program. You can either make a gift to a charity from your estate outright, or you can use that as a contingency option in case there are no other takers under your will. Be as specific as possible if you are going to make a gift or a contingent gift to a charity. Having their full legal name and address are helpful. So next we'll talk about tangible personal property. Virginia law permits you to leave a signed written list that disposes of items of tangible personal property. Tangible personal property are the things that you own that isn't real estate. Basically, if you took your house and shook it, turned it upside down and shook it, the things that fell out are your tangible personal property. It's your household furnishings, your personal effects, your automobiles, sports equipment, art, collections, um, etc. So this list, referencing it in the will, makes it a binding part of your will. So all of the will options allow you to leave this binding tangibles list and provides for the takers of such property to the extent not disposed of by such a list in the same manner as the designated beneficiary of the residue of your estate. So that means that if you own something and you've not put in the list who you want it to go to, then it's basically incorporated into the residue of your estate and will pass to the individuals that you've specified that we just talked about on the previous screens. When you're using this list, you need to be specific, as specific as possible. So make sure if you own, let's say you own multiple cars and you just write, I want my car to go to my son, but you own multiple cars and you have multiple sons, that's not specific enough. You need to clearly identify the piece of tangible personal property you're wishing to leave to someone, and you need to clearly identify the person that it's supposed to go to. So you'll say, I want my 2020 Mercedes to go to my son, John Smith, for example. Please, you'll also need to remember to sign and date each time you update this personal property memorandum. One of the neat things about the personal property memorandum is that you can do it yourself and you can make changes to it at any time, but you just need to make sure you sign and date it each time that you make changes to it. So selecting an executor. An executor is the person who carries out the instructions in your will. It's not an honorary role. There are many financial and administrative tasks involved with being an executor. The person you select should be trustworthy and responsible with good business sense. It can be your spouse or an adult child, but uh, your executor will be able to hire professional advisors such as accountants, lawyers, financial advisors, if necessary, to assist them in the administration of your estate. So some of their duties include submitting your original will to probate, gathering and securing your assets, transferring the title of your assets from your individual name into the name of your estate, making reports such as the inventory and the accounting uh, to the clerk of courts and commissioner of accounts, paying any legally enforceable debts that you have, preparing and filing your tax returns and paying taxes for you and your estate if necessary, defending your estate against any lawsuits or other difficulties, and then finally distributing your assets as you direct in your will. The law requires your executor to post a bond with corporate surety, which is basically like insurance, an insurance policy, upon qualification, upon the executor going to the court and qualifying as the executor. The purpose of posting bond is to provide funds to your beneficiaries in case the executor makes a mistake in managing your estate or actually does something unlawful, resulting in a loss of funds. You may waive surety on the bond in your will. However, your executor will still be personally liable for any loss due to theft, fraud, mismanagement, etc. If your executor is not a resident of Virginia, the court may still, and actually probably more likely than not, will require the executor to post a bond. You'll also need to select a trustee when you're getting a will from the Wills for Heroes program. The trustee is the person who will manage any assets held in trust for your spouse or children or their descendants. Like your executor, your trustee should be a trustworthy, responsible person with good business sense, which may include your spouse or an adult child. They should have the ability to carry out financial and administrative tasks. The trustee and executor may be one person serving alone or two people serving together. While an executor's role will terminate within 1 to 2 years, a trustee's role may continue for a long period of time, especially if there are very young children. If your children are minors at the time of your death, the courts require that a guardian be appointed. If the natural parent of your children survives you, that parent will likely be guardian of your children. If the natural parent of your children does not survive you, then someone must be appointed to rear your children. In the will provided by the Wills for Heroes program, we offer a section allowing you to select a guardian for your children. The guardian is an individual you wish to raise your minor children. It is advisable that you coordinate this selection with the child's other natural parent. Your selection is only effective if you are the last of the child's parents to die. Your selection is not binding on the court, since the court will do what is in the best interest of the minor child, but the guardianship designation in a will is usually given deference by the courts. So that summarizes the will that we offer in the Wills for Heroes program. That comes into play only after your passing. The Wills for Heroes program offers two other documents that are useful, may be useful to you during your lifetime. These two documents are a power of attorney and an Advance Medical Directive. So what is a power of attorney? It's a legal document which enables someone else to conduct your financial affairs. The original document or a certified copy is generally required. The document is intended to be used in case you become incapacitated and unable to handle your own financial affairs for a period of time. If you do not name someone in advance, the court will appoint someone to conduct your financial affairs for you. The power of attorney terminates on your death. The Wills for Heroes program provides a springing power of attorney as opposed to an immediate power of attorney. This means that your agent can only act after two of your physicians certify in writing that each physician has personally examined you and found you to be physically or mentally incapacitated. The attorney in fact under your power of attorney should be someone you trust and someone who understands how you handle your financial affairs. The attorney, in fact, has substantial power over your assets and can do basically anything that you can do yourself. It's the equivalent of handing someone a signed blank check to your accounts. That being said, the attorney, in fact, is a fiduciary and they can only legally act to your benefit. They cannot effectively take this blank check and use it for their own personal benefit. They must act on your behalf. Also keep in mind that the person you name may be called on to act under difficult circumstances. So be very careful when you're selecting who your power of attorney agent should be. By definition, in the Wills for Heroes power of attorney, you will not have capacity to supervise your agent. However, naming a power of attorney is better than the alternative of having a conservator appointed by the court. This is because, one, there will be a delay if a conservator has to be appointed by the court, and two, you have control over who you name versus the court deciding who should be in charge of your finances. In this program, you'll be able to name a primary agent, and then we recommend that you name an alternate in case the primary agent is unable or unwilling to act. The Advance Medical Directive offered by the Wills for Heroes program is two documents, actually. It includes a living will and a healthcare power of attorney, but it does not include a do not resuscitate. In this document, you appoint someone to make decisions about your healthcare when you are unable to do so. If you do not appoint someone, Virginia law will determine who your healthcare decision maker should be according to the healthcare decision-making hierarchy. You should appoint a primary agent as well as a successor agent in case the primary agent is unable or unwilling to act. The Advance Medical Directive is often used to refuse or consent to life-sustaining procedures, but there are other decisions which may be necessary as well. Some of the powers included involve giving, withholding, or withdrawing consent to healthcare treatment, hiring and firing healthcare personnel, moving you to a healthcare facility, authorizing the administration of pain relief medication, donating organs following your death, and obtaining the necessary health information to make informed decisions on your behalf. Your agent is not your medical doctor. Your agent does not have to be a family member, but often is. Your agent must be a capable adult with the following qualifications. Your agent must be someone who is willing to take on the role of your healthcare decision maker. Your agent must be willing to have conversations with you about your goals, values, and preferences for future healthcare, and someone you trust enough to share this personal information with. Your agent must be someone who will honor your wishes for healthcare, even if they disagree with your choices. And your agent must be someone who can be an advocate for you with loved ones as well as with the healthcare team. They should be able to think and communicate clearly in stressful situations. As with the power of attorney, this document only goes into effect after 2 of your physicians certify in writing that each physician has personally examined you and found you to be incapable of making an informed decision. The phrase incapable of making an informed decision means unable to understand the nature, extent, and probable consequences of a proposed healthcare decision, or unable to make a rational evaluation of the risks and benefits of a proposed healthcare decision as compared with the risks and benefits of alternatives to that decision, or unable to communicate such understanding in any way. With regard to the execution of documents, again, for your safety and the safety of our volunteers, this program is being offered virtually. This means that you will be emailed the final documents and it will be your responsibility to get them properly executed. You will be provided with written instructions on how these documents need to be executed, and you will need to have 2 witnesses and a notary available in order to have these documents executed. Your last will and testament must be signed by the testator, that's you, must be signed by you in the presence of 2 witnesses. It must also be signed in the presence of the notary for the self-proving affidavit. The self-proving affidavit, that'll be the final page of your will. That is the document that allows your will to be admitted to probate without the need for witnesses to testify as to the validity of the will and your testamentary capacity and intent. We recommend that you use disinterested witnesses. That means those people who are not going to inherit from your estate. But that's not a requirement by law. If the only people you have available to you right now are your family, for example, you can use them as witnesses, but if at all possible, we recommend that you use disinterested witnesses. The will execution ceremony has a script that should be followed. Following this script provides evidence to the court if your will is ever contested. Your power of attorney will need to be signed by the principal, which is you, witnesses, and a notary. And the Advance Medical Directive will need to be signed by the principal, that's you, and the witnesses. So I'm going to go over some frequently asked questions now. And then if you have any additional questions following this presentation, again, you can email me or my co-chairs at virginiawillsforheroes@gmail.com. So what if you get married after you sign this will? Marriage warrants having a new will prepared. In the absence of having a new will, the spouse may claim an elective share or other allowance. Basically, Virginia law provides uh, that spouses cannot be completely disinherited. So if you get married and you've not already left a certain percentage of your estate to your spouse, they can choose to make uh, to take the elective share or other allowances from your estate. What happens if you get divorced after you sign this will? Well, in Virginia, divorce terminates the disposition of property to the former spouse, as well as the designation of the spouse as a fiduciary. So even if your will says, I leave to my husband this amount or my whole estate, and I want my husband to be the executor of my estate. If you later get divorced, then that those provisions are null and void. However, when it comes to your retirement accounts, anything that is controlled by ERISA, anything with a beneficiary designation, uh, divorce does not automatically terminate those. So after you get divorced, you really need to revisit your retirement account and any other accounts with beneficiary designations. You will have to take affirmative action to change those from your former spouse. Also, if you get divorced, you need to review your documents just to make sure that your documents still meet your needs and get them revised accordingly if they do not. Another question: I am in the process of getting a divorce and I would like to attempt to disinherit my soon-to-be ex. Can I still participate in the Wills for Heroes program? Yes, if that's your situation, you can choose a will for a single person. But note that if you pass away before your divorce decree, your spouse can still take part of your estate by choosing that elective share. What if I have more children after I sign this will? Well, the wills offered in this program include all existing children as well as any children subsequently born to or adopted by the testator. Therefore, the new addition to the family will still take under this will. However, you'll want to look at the provisions in the will to make sure the other provisions still hold true. For example, if you had selected other guardians and trustees, you'll want to double check and make sure that such guardian is still the guardian that you would want to have for this child as well. So my child is well provided for by his grandparents. Do I have to leave my child something from my estate? The answer is legally no, you don't, although minor children may be entitled to certain allowances um, as uh, just as spouses are. You cannot completely disinherit a minor child under Virginia statutory law. However, the Wills for Heroes program does not permit disinheritance of children. That's just not an option that we allow for the drafting. My children are all over the selected trust age. Do I still need to select a trustee? Yes, you do, because the trustee will be the person named to oversee any trust that goes to a descendant who is under the trust age. So if your child has children and then your child predeceases you and then you pass away, it's the grandchild that is to take under your will. And if that grandchild is a minor, that's where the trust age comes into play. Can I name dual guardians for my children? While naming a couple may seem ideal, keep in mind that if the couple ever splits up, there may be a dispute over who retains guardianship. It is therefore advisable to name one person rather than a couple. Why would I leave my estate to my spouse in trust instead of giving it to them outright? I touched on this briefly before, but having a trust is a good idea for those you wish to ensure that their descendants receive their assets when they die. This may occur when a spouse has children from a prior marriage, or if the spouse is young and likely to remarry and have more children. Remember, if you give your estate to your spouse outright, after you pass away, your estate transfers completely to your spouse, and your spouse's will determine how the assets will be distributed. How many executors and trustees can I select? You can choose a single fiduciary and an alternative, or two co-fiduciaries and an alternative. Can I name dual agents for the power of attorney and Advance Medical Directive? You cannot do that with this program. This program only permits the naming of a single agent and an alternate agent. Can I include funeral instructions in my will? Well, the wills provided under this program do not allow for such instructions, but you should discuss your wishes with your named executor and/or prearrange the funeral. Can I provide for the well-being of my pets? Well, the program does not provide for pet trusts. However, you can bequeath your pets by listing them on the tangible personal property form. How often should I review these documents? You should review these documents periodically to ensure that the documents still meet your wishes and the named dispositions are still relevant. When I say periodically, I mean at least once a year, and anytime there's a major change in circumstance, whether it's a change in your family dynamics, a change in your finances, a change in the law. Um, those are indications for you that you need to review these documents again. Can I make copies of these documents? Yes, but be sure that you do not remove the staples or make any other alterations that may call into question the validity of the original document. You should also mark each copy prominently as copy to help prevent any confusion in the event you later revise the documents. Whom do I contact if I have questions when filling out the questionnaire? Again, send your questions to virginiawillsforheroes@gmail.com. I will be answering these questions. I am an estate planning attorney, and if you have any specific questions with regard to estate planning, I'll be able to answer those. Some final thoughts. A peace of mind in completing documents while creating a future gift to your family is one of the benefits of doing estate planning. Regardless of whether you choose to receive documents under this program, you should use this opportunity to review your accounts with beneficiary designations to make sure they are all still accurate and make any necessary changes. In closing, I want to say thank you, healthcare workers, Uh, we, Virginia Wills for Heroes, want to thank you for your service during these most difficult times. We could not get through this without you. Your courage and bravery, your selflessness, your dedication, and your professionalism are an inspiration. Thank you for allowing us this opportunity to support you.